Hi, I'm Andrew Lovett, and this is another Tax Insight from LOVETTS. Today's topic is a circumstance in a case at the full bench of the federal court where a judge really has blasted the tax office for conduct through a series of hearings in the tribunal before a single judge and then also in the appeal. The case is known as Shord's case, and it concerns an oil field diver, so that's somebody that does deep sea diving around oil rigs out in the ocean. And Mr. Shord undertook work in that area from about 1999 through to 2010, mainly offshore in the ocean surrounding other countries. And during that time, he thought that he was not a resident of Australia. He had a wife and a home here in Australia, but he thought he was working offshore and considered that he was non-resident for that time. So he didn't lodge his tax returns during that period. The tax office was aware that transfers of funds were coming back into his bank account, and at a point in time they undertook an audit of Mr. Shord's affairs. They required that he lodge his tax returns, and he didn't put into his Australian tax returns the income that he earned from doing that offshore work. And the tax office made adverse assessments, and he ended up with a tax bill of around $150,000 and interest and penalties of nearly the same amount, about $135,000, which is pretty nasty. First of all, he objected within the tax office objection system, and then when the objection was refused, he took his case to the Administrative Appeals Tribunal and contested the grounds for the tax office assessments. He believed he was non-resident. And at that time there was also a rule that if you were working offshore for more than 90 days, that income was exempt. That was called the Foreign Service Rule, and he contested the case on that basis. And also he sought credit for the foreign taxes that were deducted and paid by his offshore employers. So the tribunal is like a court, but it isn't actually a court. And it uses some of the features of courts, but not all of them. Mr. Shord was represented by his accountant in that hearing, but the tax office was represented by a barrister. At the beginning of the hearing in the tribunal, the tax office barrister made a statement basically conceding that the tax office agreed that Mr. Shord was in fact an employee whilst he was working offshore, and so that was a key statement that came back to bite later on. The outcome of the tribunal hearing was not very good for Mr. Shord. The tribunal upheld the tax office tax assessments. The tribunal said he was a resident of Australia for those years. The tribunal said he wasn't an employee. That's despite the statement by the tax office barrister at the start. And also they denied him any credit for any overseas taxes paid. So not a good outcome at all. Subsequently, Mr. Shord got legal assistance, and the case was appealed in front of a single judge at the federal court, and that really didn't go much better. The appeal was denied on all those three counts. So Mr. Shord then instructed his legal advisors to appeal to the full bench of the federal court. So it was three judges sitting in judgment on the matter, and that went slightly differently. Mr. Shord actually was successful in his appeal to the full bench of the federal court. That was a good outcome. But it was interesting because there were some very sharp comments in the in the ruling on the case. In particular, one judge, Justice Logan, made some comments that, when you read them, are pretty strong about the conduct of the tax office during the hearings through from the tribunal, the single judge case and the full bench appeal. You'll remember there was a statement by the tax office barrister at the beginning of the tribunal hearing, and that statement effectively conceded that Mr. Shord was an employee when he was working overseas. But the tribunal outcome was that he was not an employee during that time. And the statement was made at the beginning of the hearing. So the outcome of the full bench hearing was that Mr. Shord suffered a significant procedural unfairness because of what happened at the tribunal hearing. It took a very long time for this to come out. It went through 3 hearings, well, three separate jurisdictions. There might have been more hearings than that. The comments from Justice Logan, he was really criticising the tax office and their representation, basically saying that the procedural unfairness was very obvious, it was patent. And the tax office had an obligation, because the tax office is the government, to conduct itself as the term is a model litigant. So in other words, it must conduct its litigation with the utmost of probity. And the tax office had a responsibility to bring that procedural unfairness to the attention of the judge in the single judge matter, or to the 3 judges very early on in the full bench hearing. Justice Logan made the point that the tax office, the Commissioner of Taxation, when they're in litigation, bears the full responsibility that the government itself would have in undertaking litigation. He went back through some old history from England, from the United Kingdom, and the trouble that gave rise to the Westminster system, where the courts, the Crown and the Parliament are separate powers, and how that's reflected in the Australian Constitution. He then said it was very regrettable that the tax office had not quite fulfilled its obligation to conduct itself as a model litigant in this particular legislation. To quote, he said it was most regrettable that this patent error was not drawn to the tribunal's attention by the tax office forthwith after the decision was published, and not having been drawn to the tribunal's attention at that time, it was not subsequently brought to the court's attention. He further went on to say that departures from model litigant behaviour can, in particular circumstances, constitute professional misconduct, a contempt of court, or an attempt to pervert the course of justice. They're pretty serious words. It's interesting that the other 2 judges didn't quite agree with Justice Logan. Indeed, in their comments, they completely disassociated themselves from the criticisms of the tax office. The outcome was nonetheless in the favour of Mr. Shord. Because of this procedural unfairness, he won the appeal and the assessments were dismissed. It was a good outcome at the end of the day for the taxpayer. That's been another Tax Insight from LOVETTS. If you'd like the full article, please go to our website, lovetts.com.au.